Hi, Tonya. How are you?
I'm good. How are you?
I'm okay. It's very nice to see you,
Nice to
and
see you too.
and nice to see you again for our Wicked series. Although this time we're going to be talking, it's not more about you, it's actually more about what you're doing.
Yeah.
And a particular case that was in the news recently, you were co-counsel, well, it was your client, but there was another lawyer also, Chris Sewrattan. We're going to give him credit, although we want to hear from you today. We like Chris, but today we want to hear from you, Tonya. So maybe you can tell us about this case, the citation of the case, the name of the case, and what happened in this case.
So the name of the case is Queen versus Al Hajj Salam, or now I've
Al Salim. Yeah.
Al Hajj Salam. And I can actually tell you, if I just have one moment, I'm going to look here. I'll give you the citation. It should be on LexisNexis, I would think. Do I have a citation? No, he has it as a court file. But in any event, I can always send it to everybody, and the people can ask me for it and reach out to me. It's not a problem.
And it's a 2023 case.
Yes, 2023 at the Ontario Court of Justice in Newmarket. And the last name is ALHAJSALEM. And the first name is ALAELDDEIN.
Alauddin, yes,
exactly. So that was a case that basically started in Newmarket. And my client had, there was 2 charges of robbery with violence, which essentially were carjacking charges. And he was arrested. The case didn't look great for him. And the family retained me to conduct the bail hearing. And when I went to the bail court, we were still like in the pandemic, but court was still running and the bails were still running. And when I came to court, they were like in that particular court. So there's like in Newmarket, there is like a set date court for bail. Like it's like a video court. It's like quick 10 minutes. So you don't do bail hearings there. You have to schedule the bail hearing in another court. So I said, okay, well, we're ready. And like after the first day, I had to figure it out because he had warrants in Scarborough and in Halton region. So he had 2 different warrants in those places, like bench warrants. So they weren't consenting. And I presented a plan and I said, okay, 2 sureties, house arrest. And because one of the sureties only spoke Arabic, they had said, oh, well, this is a special bail because you have 2 sureties. One of them is speaking Arabic and it's going to take long, blah, blah, blah. So I said, okay, well, I'm ready to have the hearing. Oh, well, you have to book a special hearing. So I said, okay, fine. So I sent my email like ASAP to the trial coordinator office. They were like, oh, this is a special. I'm like, I sent everything like very fast because I was like, let's just get this guy out because I figured he could get out. He has no criminal record. So I thought, okay, this is going to be no problem. He can get out.
Yeah.
So I don't remember the exact dates. It's probably in the decision, but let's say I said I was available, April 1st, 2nd, 3rd, and 4th. The first bail date they gave me was April 8th. So I said, no, this is not acceptable. I sent an email to the trial coordinator about the fact that it wasn't acceptable. They didn't even really respond. They were just like, well, this is the date we have. So I said, okay, that's fine. But I then made my comments on record about how all the dates I was available, how long we were waiting, the fact that I noted to them that it was unacceptable when I sent my emails, when they were responding, and they didn't really do anything and put it over to April 8th. So we get there on April 8th to do the bail. And first of all, it was booked off for 4 hours at the jail, because we had the interpreter and the 2 sureties. The officer comes on and says, oh, we only have 2 hours today. So I was like, well, this is not acceptable. But we started anyways. And like they said, they were going to cut us off. And I said, well, let's see if we just finish it. Then by the time the sureties testify, the 2 sureties, the Crown then goes, okay, we'll consent. So that's the only reason why I got done in 2 hours, because they consented. They didn't cross them. We didn't do submissions. And they consented. And then on top of it, later on, exactly what I said I was going to do, he got released on a house arrest, which was fine. And they let him out from the jail. He simply went to Halton. I called them in Halton and I said, look, he's already on a house arrest. There's no point to hold him for bail because there's no other bail he could get. They released him on promise to appear. And then I made them drive him to Scarborough. And then he went to Scarborough and got a promise to appear. And that was it. So the situation, the issue here was obviously that he waited like 16 days to have a bail hearing, which is like completely unacceptable.
When he was ready.
Yeah, he was ready. And he waited 16 days, which is completely unacceptable. So obviously I recognize this. That's why I protected the record as soon as that happened. So as soon as it happened, I didn't leave it. Duty counsel obviously could protect the record as well. But sometimes, duty counsel is overwhelmed and very, very busy. So I made sure I had to protect the record. I made sure my emails, was very clear about my availability, very clear that this date that they were giving me was not acceptable to assist, because I knew that I was going to pursue this application. So we pursued it, and we had Justice Dwyer in Newmarket, who was the judge. He saw our factum, Chris Sewrattan's and I's factum, and then obviously saw the Crown's factum. We made short submissions, and then he made a decision and found that my clients, although like the charges were serious, it was 2 carjackings, was serious, but found no, there had to be a stay because it was just, the weight was unacceptable, and it was continuing after my client's bail. So one of the things you have to know with the application, it's not simply that your client's rights were violated. You have to show that there's a systemic problem in that.
Right. And that's explained actually in the decision.
Exactly. So
that it is a problem apparently in Newmarket, that
yes.
There is, and there were other cases I think that were referred or that were cited as well in the decision.
For example, a case called Zarin Chang was also cited in the decision, which discusses, particularly in Newmarket, the issue with waiting for bail. And so that's how that happened. And the thing is with this case is, like, first of all, there's definitely, I've already been reached out to by, and I'm sure Chris has as well, by different counsel asking, okay, can we see the decision? Can we see the materials to see, because they have their own issues either in Newmarket or in other places, because this is not just a Newmarket problem. This is a problem going across at least like the GTA. I don't know about other places, but at least the GTA, this is a big problem. And the implications, I think, of this case and what it means for future cases is now counsel, there's now a decision. So now there's going to be counsel saying, okay, you know what, maybe I have the same type of circumstances. I was ready to run the bail. Someone just called me today saying that they were having the same problem in Newmarket still. So I don't know what's going on there. And she was saying that there's still a problem, and she wanted to see the decision because she's going to show it to the Crown that is maybe giving her a little bit of hassle. She believes that there's a directive. They must have done some sort of change, but it's not clear what the directive is. But frankly, if it keeps going this way in the GTA courts, we're going to see more of these applications. We're going to see more lawyers applying for those stays and saying this is simply too long to wait. So it's been too short of a time to notice a difference really of how they're dealing with it. I think we have to see longer to see, okay, what the changes that they make. But I think one of the things is going to be, certainly, I think that how they can fix this in a way, the police, it starts at the police. You're holding everybody for bail unnecessarily. And this is where you're causing the overcrowding. And then you're having bail courts, like there's the new Toronto bail court, how everything is now in one bail court.
One courthouse,
They've literally been sitting till like 9 o'clock at night on some days in bail court. And even there was another day, it was in the paper that 4 consent releases went overnight, like that they did not deal with them that day. Imagine that you have a consent release, they're releasing you, but now you have to spend the night in jail, which is like unacceptable. So I don't know how, like the way either they're going to respond in either becoming more reasonable in bail, which I don't see happening, because just look at the discourse right now. I don't know if you heard about that case recently. This guy stabbed another guy on the subway the other day here. It's actually near my house at Yonge and Eglinton, at Eglinton Station. Stabbed some guy. And now they find out he was on bail. He wasn't showing to court. So now there are papers saying, oh, how did he like not show up to court, but then he still got bail in another jurisdiction? Because they're making it about, oh, we need to make bail conditions stricter. And it's such a stupid discourse, frankly. And it's like dog whistling to like stupid people. And I'm sorry to say that, but it really is, because people do not understand the issue is really like how to help people. So if you're saying, oh, someone did something wrong, so they just shouldn't get bail, like what's the solution? Are we just going to, like, every time someone gets arrested, we're just going to throw them in jail and not have bail, right?
And in your case, Tonya, it's not, I don't remember it being mentioned in the case. I had to ask you that before we started recording. Your client didn't even have a criminal record. I mean, so that in itself should give some kind of assurance that, like, okay, yeah, maybe the facts right now seem bad. And again, they seem bad. And that's another problem, that when you read, especially at the level where you are, it was the bail stage. So it's very early on. All you have is the Crown version. You probably don't even have time to speak to your client and to know what really happened from his side. So
Exactly.
of course it's going to look like it's horrible, but again, he doesn't have a criminal record. So that should give some kind of comfort that, okay, if he's getting into trouble, it's something new. I agree that it could be maybe more problematic for someone who has a history. People will be concerned and afraid, but here he didn't even have a record and he had to wait for so long to have his first bail hearing.
And that's what's unacceptable. And what is sort of like annoying is like making this big deal and not consenting. And only when you hear from the two sureties, when you consent.
And couldn't they speak to them before? I mean, sometimes crowns have the opportunity to speak to them before, like making the courts waste time in an actual bail hearing.
Exactly.
So,
exactly.
And so, that didn't happen, I guess, in your case.
No, it didn't. So it's just sort of the attitude was, these are serious charges. And I think also sometimes, I don't like, it comes to like these political thoughts, because I don't know if you like in the GTA, there was like this issue of rash of carjackings. So,
oh yeah,
like,
especially with youth. Yeah.
Right. When they see that, and he's not a youth, but he was like in his 20s. When they see that, it's like, oh, we have to show that, we're serious about this. We're not going to agree to release. But that's not the law. You can't look at a particular offense. Like, yes, they're allowed to take like JPs and crowns are allowed, like they're allowed to take judicial notice of things and say, okay, you know what, this is really serious. We keep seeing this happening. We have to take a stand. But the law of the bail still applies. People still have their charter rights to have a reasonable bail, and people still have their right to have bail within a reasonable time frame. Right?
Yeah, and I mean, one way they can, if they want to address the concern, the safety concern, make sure that doesn't happen again, is just put conditions that would address that, but release the guy and, give them, some kind of liberty. So, okay, so, that's one thing that's interesting here, is that, the whole fact that you got that excellent decision, that the proceedings were stayed. But then what's also very interesting about this case is, we know that stays are very difficult to get. It's only in the clearest of cases that you can get a stay. So it's already hard to get a stay in general. But here it is, you're getting it at a very early stage. And that's what makes this case more interesting, is that you're getting it when you're still at the bail stage. Like, it's not like you received maybe disclosure at this point. I don't think you even had a chance to get.
We did receive disclosure. There was a trial date set even. There was
okay.
Date. Oh yeah. So the trial date was actually for the end of June. So it was supposed to be for 3 days, because there was actually another co-accused on the case as well. And so the thing is, with the trial date, usually I heard that some people say that the application's actually heard after, like when you want the stay, you have
the stay. Yeah.
But Newmarket seemed to want it before, because I think for them, it makes sense to have the application before, because they want to save, like basically get be able to use those dates.
Yeah.
So we had it as like a pre-trial motion. So we had it like, we do it before, and then if we lost, then of course we just go ahead to the trial. But if we won, then the trial dates were vacated, which happened for him. The trial dates were vacated. So we did end up having like JPTs and having disclosure and getting disclosure and all of that. We did.
Okay, so because that wasn't also very clear in the decision, I think it was just that they were only addressing the bail stage. But still, he didn't get to his trial, so it got stayed before that, and now he's a free man.
Yeah.
But so, you said that it was too early right now to see what the implications of this case are, or how, if there is any implication right now. But there is kind of an implication in the sense that you're getting a lot more calls from lawyers asking you who are in the same situation. Unfortunately, it seems like the situation hasn't really changed, because if there are still lawyers who are contacting and saying that they have a similar situation and they want to get a copy of the decision. So the problem is still ongoing despite this case.
And it might be that maybe it's something that happened, like if they're looking at the case and maybe they're looking at, when they went for bail 2 months ago or something. But regardless, it is still a problem in a lot of the courts. So at least like right now, what I meant by not seeing implications, like I'm not seeing any, like it's too early to say that we see a change in how the court is operating. Like if the court, like let's say they decide to open more bail courts, or they decide, okay, we're going to take a different approach. or if the police are now taking a different approach and saying, look, maybe we'll release people from the station, but put stricter conditions. Like, I don't know. But yes, you're absolutely right that what I am seeing is counsel reaching out. And I'm sure Chris can say the same thing. Counsel reaching out and saying, hey, I might have something like this. I want to see the decision so I can, decide whether I'm going to pursue that too in their region. And it's not just Newmarket. So I don't want to step on, say Newmarket, only Newmarket. This is across the GTA, these problems, like they're happening at the Toronto Bail Court. I heard that in some cases happening in Milton. So it's happening in a few court jurisdictions where it's just like you can't get a bail.
And it's a case where the delay was really mainly caused by the courts here. It's not defense, it's not the Crown, it's not an issue of disclosure, it's not, it was really the court's problem in this case.
And it's really the court, the issue is the court didn't have the resources. So the resources to have more bail, I don't know if it's justice of the peace, or I think it might be literally staff, right? To staff these courtrooms, to have people there to have the bail is the issue. So if you don't have that and you have, like, let's say 15 people want to run their contested bail today, how is that going to happen in one day in one or two courts? Sometimes these bails go long, depending on, the charges, depending on the sureties, how many sureties someone presenting. Does the surety have to have it interpreted in a different language? Because that does add time, it does, but that shouldn't.
And yet I thought that Zora kind of addressed a bit that issue, and they said that you don't really need a surety each and every time, right? Like, you don't need that. It just makes the bail process heavier, because every time you have a surety, and if the Crown wants to hear from the surety, or if the JP or judge wants to hear from them, that adds a lot of time, unnecessary time. You can just, ask them a few questions before court and not waste court time in bail.
Some Crowns take the position that they have to hear from the surety. I won't say where, but there's a particular place where there's Crowns that will say that they must hear from the surety. Oh, they can't consent. I don't know. I haven't heard what the surety has to say. And I'm just sitting there being like, Tani tells you don't have to hear from them, but they insist on running it. And what's going to happen, I think the lesson will be learned. I hope that more defense counsel will start bringing these more often, and we just have to keep bringing stays and people, and see how the public is all riled up because people are, Lord forbid, on bail and released and do something. Maybe the public get riled up when we have a lot of stays, when people are walking away from cases because you're simply violating their rights. So maybe we'll have that, and they'll have to have those resources to have bail.
No, definitely. I mean, we do have a problem with the bail system, and I think we see it all over the news right now, that there is this systemic problem, and hopefully maybe this case will help a bit.
Well, I think the news is framing it a different way.
I agree.
The problem in a way that I find to be very problematic. They're framing it in a way of these people essentially shouldn't
be released. And that's why we are giving you the opportunity to speak about this case, because then you can get to see the other point of view and what really happened. Not sometimes we read in the media, but I don't know how many of people who write about bail necessarily have been doing these cases themselves. So, here, that's the whole point of this interview, is that you were counsel here for Mr. Al-Haj Salam, and you know what's going on. You have firsthand experience of the problem that was going on. You know the dates that were offered when you were available, and it's not on the defense, it's not on the Crown. It really was a problem here with the court, and you were going to run a bail hearing, and it did, and they didn't even give you the full time that you were supposed to have. So it's really
it's one of those things. And I know I wouldn't say it's not a problem with the Crown, because I think the Crown also, and I said this before in the interview with the Toronto Star, is that the Crown also needs to be more reasonable in their positions. Because when you have someone
and the police also, as you mentioned earlier, the police can also.
So it's not just the court, it's the police, it's the Crown. When we take these unreasonable positions for the sake of taking them, regardless, especially knowing when someone's likely going to be released, it's wasting resources, it's wasting the court time. It really is.
No, I mean, I agree. I mean, you did point here something really important. It's how this whole bail issue is being framed by the media. And we did recently see what happened with one of our justices of the peace in Ottawa, who wrote an article a few years ago about, like her personal observations of what's going on in bail courts, and how, like she just mentioned that there were some issues with the way crowns were handling bail courts, and how that was met, then the reaction and what it cost her. So it is, like it's our responsibility to show the other side that people don't necessarily see in the media. So great job, Tonya, in this case. Congratulations. And, maybe if it's just one case for now, but that's how we build, right? Like that's how we build then jurisprudence, and we build precedents. So it's one case that we add to another. And hopefully we'll have more of these stays in these kinds of situations.
Yeah.
So thank you so much for your time. I know you're really very busy, but I really wanted to hear from you about this case, and good luck with any other new case that you get that's similar to this one.
Let's see if it happens again. I don't know.
Yeah, and then we'll have you back then to talk about it.
Okay.
Thank you so much, Tonya.